way in which the governor can interfere like this, especially in a case where disqualification is sub judice or pending. Actually, setting up the ground as a precursor, come to me, I will swear you in.
What is the power of the governor to call for a trust vote post formation of the government? What are the circumstances in which he can?
That means a running government.
A running government.
Correct. My candid, clear answer to your lordship's direct question is zero. Number one, can you disable the speaker so easily, thereby sounding the death knell of 10th schedule? My lord has heard it fully. Navam Rebia is the main standing obstacle, and we have argued on that. That's consequence number one. Second, is the positive and the negative injunction. I'm just tying up the ends together into a list, which are against Quixote. It is not only the practical effect of this positive and negative injunction, but it is juristically against Quixote. So the second part is, the positive and negative injunction is not only factually wrong and has caused the change of government. That has caused, I made that argument earlier, but it is juristically wrong. That's the second consequence your lordships should rectify. Only Supreme Court can do these rectifications. Nobody else can. Well, it's really futile to have a whole ladder again starting some High Court, the ladder going all the way to Supreme Court. It really is futile. Nobody can touch. These are Quixote, these are Navam Rebias. Therefore, third is the consequence of the governor's direction for a floor test. There is no way in which the governor can interfere like this, especially in a case where disqualification is sub judice or pending.
The consequence of the governor's direction for a floor test.
Floor test in a pending disqualification matter. Sub judice at two levels, sub judice at your lordship's level, sub judice at the speaker's level. It's a double sub judice. He's after all deciding in a quasi-judicial capacity there. As a tribunal. Executive has no role to come into it. Laterally, sideways, the executive can't enter it. The governor is, though a constitutional post holder, an executive appointee. So this third aspect is really the executive direct lateral entry into a no-go area. Totally impermissible. That's a consequence a lordship alone can rectify, should rectify. That applies to all these consequences. Somebody else will decide. It will be a partial decision. Supreme Court, for the polity, for constitutional morality, for the whole system, must decide.
This is part of your third point only.
This is under consequences, C. First point is consequence, ABC. This is the third one. The fourth one is, it is distinct, but it relates to the governor. The governor recognizes a split. Well, if your lordships can't do it, governor will do it. The Supreme Court with 142 today, if a judgment is passed under 141, 142 saying we recognize a split, your lordship would be acting contrary to governors. The governor can do it. Directly recognizes in writing a split with great respect. Here there is an inbuilt double whammy. The governor is an error as a constitutional holder, and the executive is coming into and recognizing. The central government executive is coming in and recognizing a split. Now that letter, your lordships may not have seen for some time now, maybe in the beginning it was shown. Just turn to that letter, for a minute. But those people are. He's writing to Uddhav Thackeray. 3. He is doing it under the nose of a pending disqualification, then scheduled proceeding and a hotly contested Supreme Court matter. The ordinary mortals who are doing it, your lordship take a very serious view. I know your lordships can't issue directions to the governor and content may not lie. But just consider, Manoj, if anybody else would write a letter like this, when your lordship is hearing such a heavily contested matter and the speaker is dealing with it, I don't know, Manoj, normally, Manoj, we'd expect some contempt notice. Then some appropriate case will also examine how far the arc of immunity applies. Number 4. He is, Manoj, actually setting up the ground as a precursor. Come to me, I will swear you in. This is an advance intimation. This 7th para read as it is can only say, come to me, I am ready to swear you in. Because you are kosher. There is no problem with you, there is no stigma. Only step left is that, nothing is left. Therefore, Malaj, to the other question, my lord, the Honorable Chief Justice asked me on Thursday, Malaj, what is it that you want us to do in the event that we agree with you? Or should put a question like that. One of the simplest levels, of course, I gave you a larger answer, simplest level is to quash this letter. Now, suppose your lordship quashes this letter, just for a minute. And I do not press, except for 1 or 2 things, in any meaningful way for other things. Just suppose, I'm just not conceding anything, I'm just giving the lordship a supposition. The status quo ante is automatically restored. Lordship doesn't have to say it. And is that constitutional morality? Is that fair play? Is that upholding the greatest traditions of governance? Because clearly it is. And certainly, Manoj, there can be no bar, immunity, hesitation, legal obstacle, constitutional bar from quashing this letter if your lordship otherwise agrees with me. This letter is not a non-quashable document, Manoj.
It's directly impugned.
It's a direct prayer, directly impugned in all the writ petitions or many of the writ petitions. Take it, Manoj, take it that it's impugned. I don't know if you should take out the prayer. No, not from here. So, now, Manoj, this is the 4th consequence. The 5th is a obvious consequence of this consequence. Next step is swearing in, which happens on 30th. This is 28th, 30th. In fact, the seeds of that are very clear in para 7. I told you it's an advance intimation. It happens 2 days later. So that's a letter saying you are kosher. That is acting on the letter and giving you a constitutional status of a minister. Well, in fact, I'm sorry, that swearing in was the chief minister. 30th was the swearing of Mr. Shinde.
Chief Minister, correct. 38.
So you are swearing in a constitutional head of state. And what is the last consequence is again consequential to the consequence, which is appointment of the speaker. If I may say the new speaker or the speaker. And this is very important, Willis. 4th, only your lordship. I'm not saying your lordships may. I'm saying only your lordships can decide and should decide this. I'm not even making an optional. According to me, this is only the Honorable Supreme Court, which can and should decide it here, not delegated to any other authority. In case of a merger, suppose 8 out of 10, 6 out of 10, 9 out of 10 leave, the remaining chap left behind is protected. Under your lordship's 10th schedule is protected. He otherwise he's a loner. He would himself be he's protected. Here, Manas, but for your lordship's interim order, which we argued just a few days ago. I'm not protected. Without claiming merger, I mean, today they are issuing letters and whips, which I'm not talking about lordship's protection. The whip is being issued as we speak, in various matters, they are entitled to, if the EC has recognized them. But for lordship's protection, I would be liable to be disqualified for not following his whip. Because without invoking merger, without getting a merger, there is no protection. They become the party. These are consequences. This is a consequence lordship I added my 6 consequences. This is a very weird consequence. It's a very weird consequence. If you have the defense of a constitution, you are worse off. If you don't take the defense of the constitution, you are better off. I should have mentioned in the consequences list, lordship will consider putting it there. It's an absolutely absurd, weird consequence. Then, I have extracted para 4 in para 23, that is para 4 of the 10th schedule. And I've made this point in para 24 again. And therefore, I have ended with this. I'm ending my submissions with one judgment which I have to cite. That's an absolute end. That's an interesting judgment on where is it found? Where is it found?
3F.
Compilation of judgments,
3F.
volume
3F.
3F. It's a judgment called Indore Development Authority 2028 SCC 129. Constitution bench.
On restitution. On restitution.
Yes. Your lordship is a party to it.
Restitution, no?
Restitution. Because that's the 5th facet or 6th facet of setting right a wrong. You call it actus curiae, your lordship will not allow your lordship's acts or judgments to harm a party. Your lordship calls it a situation created by a lordship's order, etc. Another facet of saying the same thing is restitution. And my lord is absolutely right.
Which page you want to read?
This one I will not read the quotation. Just pause here for 5 seconds, fellows. I get an interim order. The interim order is obviously not confirmed. If the interim order is confirmed, the matter doesn't arise. It is other way around. But every consequence of the interim order is enjoyed, gorged, eaten, and then you twiddle your thumbs and say, tough luck. Now the final order has come too late. You can't ask for restitution. That is what your lordship seek to address by this passage. It's rather well put. For saving of time, I'm not reading. I would request my lords to read Eastern Coalfields, from where it draws strength. It's a constitution bench. And this is the essence of justice. It's the essence of justice. In a constitutional matter with such grave consequences, it is even A for sure. I'm very deeply obliged.
One question I had, it's a facts part. You said, and both Mr. Sibal also said the same thing, that this is not a case where a trust vote is called when the House is constituted for the first time. So that the governor's powers, of course, the governor has the power to call for a trust vote when there is no clear majority on the floor.
But not after the election that you have for the first
time. It's not after the election because here the government is formed. Very valid point that, this is post-formation of government. What is the power of the governor to call for a trust vote post-formation of the government? What are the circumstances in which he can?
That means a running government.
A running government.
Correct. Well, let me answer on first principles. Of course, we can add some material and give your lordships specifically and note only on this. But on first principles, the first answer is that 0, where? Because your lordship will decide abstract. 0, answer to your lordship, direct question, direct answer. 0 power, where there are pending disqualification issues in a running government. Because the lordship should not mix up the two. One is a normal vanilla running government with no issue of disqualification. One is a disqualification pending at 2 levels. My candid, clear answer to your lordship's direct question is 0. Number 2, the reason is what I have given. It is a lateral entry of the executive in an area where there cannot be any jurisdiction. There is no locus for us in either 10th schedule or lordship jurisdiction. Number 3, if your lordship's question is premised, has to be premised and rightly premised on the assumption that the governor, what he does in the question posed by the Honorable Chief Justice, what is he doing, He is recognizing ABC as the inverted commas majority. There is no relevance to your lordship's query unless the governor does that. Otherwise, your lordship's query would not be relevant.